Okay, let's orient ourselves. It is January 18th, 2026. If you've been anywhere near a newsfeed, a whole screen, or even just a classic newspaper in the last 9 days, you know exactly what headline has been, well, dominating everything.
Been hard to lisp.
President Trump is back in headlines, and this time he is dismissing Denmark's claim to Greenland. But look, usually this kind of story is just fodder for late night comics, geopolitical theater. But looking at the stack of research you've brought to the table today, there is something buried in his specific phrasing that is, well, it's explosive.
It is. And to be clear, it's not explosive because of the friction with Denmark. I mean, that's just standard diplomacy. It is explosive because of what it accidentally implies about the United States itself.
Right. So let's get the put on a record. This is from January 9th. The president said, I'm quoting here, the fact that they had a boat land there 500 years ago doesn't mean that they own the land.
It's such a classic line. And in context, he was using it to pivot to modern security concerns. He mentioned Russian submarines, Chinese destroyers in the Arctic. He is arguing for what we might call strategic reality over historical legacy.
Which on the surface sounds like common sense to a modern ear. Most of us listening would probably agree, right? Just because the Viking landed somewhere in the 1400s doesn't mean Copenhagen owns it today. But here is the mission for this deep dive. We are going to take that sentence. Just because a boat landed there 500 years ago doesn't mean they own it, and we are going to treat it like a boomerang.
I love that image.
When you throw that argument at Denmark, it curves right back around across the Atlantic, and it decapitates the legal foundation of the United States property law system.
That is the perfect way to frame it, because if that boat logic is invalid for Denmark and Greenland, we have a massive, massive problem. That exact logic is the load-bearing beam for the entire U.S. property system.
So if we pull on this one thread, we essentially unravel the whole sweater.
We unraveled everything.
Yeah.
And to understand why, we're going to have to go back to a Supreme Court case from 1823. It's called Johnson versus McIntosh. We need to talk about a collusive suit, which is basically a rigged trial, and we definitely need to talk about the Vatican.
Wait, the Vatican?
Oh yeah, the Pope is involved, or at least the papacy was involved, until they tried to back out of it recently.
Okay, I'm hooked. Let's start with the legal reality. When the president says a boat landing doesn't equal ownership, he's attacking a concept called the Doctrine of Discovery. I remember skimming this in high school history, maybe in like a sidebar in the textbook. But you're saying this isn't just history, this is active law.
It is the law of land right now. To really get it, we have to look at Chief Justice John Marshall, 1823. I mean, this is the titan of American law, the guy who basically defined the Supreme Court's power. He is looking at a map of America, and he has to answer a binary question. Who owns this place? Is it the indigenous people who have lived here for 10,000 years? Or is it the European powers who just showed up?
And obviously, since we are sitting in a studio in the United States, we know who won. But how did he justify it legally? Because you can't just say, we have more guns, so we own it. Courts need a theory. They need a precedent.
Exactly. Might makes right is for warlords, not judges. Marshall needed a legal wrapper to make the land grab look legitimate, so he formalized the Doctrine of Discovery. He ruled that when a Christian prince or a European sovereign discovers a land, they instantly gain what he called the exclusive right to extinguish indigenous title.
Okay, hold on. Let's break that down. Extinguish indigenous title. That seems to imply the indigenous people had title to begin with.
And this is where it gets really technical but fascinating. Marshall created a two-tier property system. He ruled that indigenous people retained a right of occupancy.
Occupancy, like a tenant.
A little bit like a tenant, yeah, or maybe even a long-term guest in a hotel. They could live there, hunt there, fish there.
Yeah.
But they did not hold what lawyers call fee simple title.
Okay, for the non-lawyers listening, unpack fee simple.
Fee simple is the legal term for absolute ownership. It's what you think you have when you buy a house. It means you own the dirt, the rights, and crucially, the ability to sell that land to whoever you want. Marshall said, essentially, you indigenous folks can stay here, but you don't own the dirt in a way that allows you to sell it to anyone but us.
So he converted the act of discovery, I mean, literally just showing up and planting a flag into a superior legal claim than thousands of years of resident.
That's it. He explicitly converted arrival into dominion.
Did he? I mean, did he realize how crazy that sounded? Even in 1823, surely someone was saying, hey, people already live there.
You did. And this is my favorite part of the decision when you read the source text. Marshall actually kind of apologizes for it. He calls the principle extravagant. He admits that converting discovery into conquest is a huge leap.
So why do it when I just say this is absurd?
Pragmatism. He basically argues, look, England, France, Spain, and Holland have all agreed that this is how the game is played. It has been asserted and sustained by everyone, so it becomes a law of the land questioned.
That everyone else is doing at defense.
Precisely.
Yeah.
But he tried to dress it up morally, and this part is really tough to read with modern eyes. He argued that the European powers convinced themselves they had provided ample compensation to the indigenous people for taking their sovereignty.
Compensation? I assume he doesn't mean gold or trade good, no.
He wrote that the compensation was bestowing civilization and Christianity upon them. Wow.
We took your land, but hey, you got civilization. That is quite the trade.
And it gets darker. He had to explain why they couldn't just respect indigenous ownership. He used very specific language. He called them fierce savages, whose occupation was war. He famously wrote that to leave them in possession was to leave the country a wilderness.
So the legal logic relies entirely on a cultural judgment. It's you aren't farming the way we farm, you aren't building cities the way we build cities, therefore you aren't using the land, so we can take it.
Correct. The title to the United States relies on the distinction between the civilized discoverer and the savage occupant. If you remove that distinction, the entire legal argument just collapses.
Which brings us right back to the boomerang. If the president in 2026 says arrival doesn't matter and imply that we should respect the political reality of who actually lives there, he is kicking out the legs from under John Marshall's chair.
Exactly. But before we get to the modern fallout, there is a twist in the 1823 case itself that I think most people miss. And this is the part of your outline that really surprised me. We talk about Johnson v. McIntosh like it was this big organic fight. But the sources suggest it was, well, kind of fake.
Fake might be too strong, but staged be accurate. It was what's known as a collusive suit.
Explain that, because usually in court, party A hates party B, and they are fighting over money or land.
Right. But in this case, look at the players. You had the plaintiffs, the Johnsonnaires. They claimed they owned a massive chunk of land in Illinois because their father bought it directly from the Piankashaw tribes back in 1775.
Okay, so a direct purchase. Private buyer, indigenous seller.
Then you have McIntosh. He has a piece of paper from the U.S. government, a patent for the same land issued much later, around 1818.
So the conflict is, who creates the valid title? The tribe or the federal government?
That's the conflict on paper. But in reality, both sides were funded by the same group of massive land speculators.
Wait, hold on. So the same money was behind the plaintiff and the defendant?
Yes. These speculators were sitting on millions of acres of Indian land being bought cheaply directly from tribes. They needed to know if those deeds were worth anything. They wanted to sell them to sellers for a huge profit. But nobody would buy them as the title was shaky.
They needed a receipt. They needed the Supreme Court to bless their business model.
Or kill it. Honestly, they just needed certainty. So they hired the lawyers for both sides. They agree on the facts beforehand, what lawyers call a case stated. There were no witnesses calling each other liars. It was just this queen narrative designed to force the Supreme Court to make a rule.
It sounds like a friendly wrestling match where everyone knows the outcome is less important than the show.
A little bit. But here is where it gets really interesting. They actually lost. The speculators wanted the court to say, yes, tribes can sell to private citizens. That would have made them incredibly rich. But Marshall ruled the opposite.
He ruled that tribes can only sell to the federal government.
Right. Marshall sacrificed the speculators to save the empire. By ruling against Johnson, he solidified the federal government's monopoly on land. He said, sorry, private citizens can't buy from tribes because tribes don't own the land. We do, because of discovery.
So the speculators lost the battle, but the U.S. government won the war. They secured that load-bearing beam that holds up every single property deed in America today. And this connects back to an earlier case, doesn't it? Fletcher v. Peck.
Yeah, that was the Yazoo Lamb scandal in 1810. Marshall had already ruled there that even if the law was born of corruption, the courts wouldn't invalidate property rights of innocent purchasers. So by 1823, the court was already primed to prioritize the system over the justice of any single transaction.
Okay, so that's 1823. Let's fast forward. It is so easy for a listener today to say, okay, that's bad history, powdered wigs, bad morals, but we've moved on. We don't think like that anymore.
Right, we have iPhones in marked colonies now.
Exactly. We culturally don't think like that anymore. And that's why the president's comment about Greenland resonates. When he says, arrival alone does not generate sovereignty, we all kind of nod. We think, yeah, obviously, it should be about who lives there now. Self-determination.
But legally...
Legally, we have not moved an inch. And this is the scary part. The sources point to a case called T-Hitton Indians of the United States. This is in 1823. This is 1955.
Oh, this is on the radio. The Cold War is happening. This is modern America.
It is. In this case, the government had taken timber from plant land in Alaska. The tribe sued. They said, hey, the Fifth Amendment says you can't take private property for public use without just compensation. You took our trees, pay us for the wood.
Seems straightforward. If the government takes my backyard to build a highway, they have to pay me market value.
But the Supreme Court said no. They cited Johnson v. McIntosh. They cited the Doctrine of Discovery. They ruled that because indigenous title is just permissive occupancy, it is not property under the Fifth Amendment.
Wait, so the Constitution protects property, but because of a boat landing in 1492, indigenous land isn't actually property.
Unless Congress explicitly says it is. If it's unrecognized title, meaning no treaty, no statute, the government can take it, resources and all, and owe $0. What, Meg, is functional confiscation?
It is, and that ruling creates the quiet promise of real estate today. Every time you buy a house in the suburbs, your fee simple title, your absolute ownership, only exists because the government stripped that ownership from the original inhabitants using this doctrine. This is why the Greenland comment is such a split-screen moment. On one screen, you have the executive branch in 2026 saying ancient discovery claims are silly. And on the other screen, you have the judicial branch saying ancient discovery claims are the only reason we have the authority to govern.
It's a massive contradiction. And to make it even more awkward, we have to bring in the third player, the moral authority, the Vatican.
Right, because discovery wasn't just a legal idea. It started as a religious one with the papal bulls.
The Inter Cetera from 1493. Basically, the Pope drew a line on the map and said to Spain and Portugal, go forth, conquer, and convert. That was the original permission slip for the Christian princes Marshall was talking about.
So what did the Vatican do recently?
In 2023, they issued a formal repudiation. They disowned the Doctrine of Discovery.
And broke up with it.
Hard. They said it is not part of the teaching of the Catholic Church. They acknowledged that those documents were manipulated for political purposes to justify immoral acts. They basically washed their hands of it completely.
So let's look at the scoreboard here. The Church, the spiritual father of the doctrine, says it's immoral and defunct. The president, the political leader, implies it's illogical and outdated. But the courts...
The courts are left holding the bag. They are the only ones still treating this 15th century fiction as if it's reality.
It's like the landlord admitted the lease is fake, the original architect admitted the blueprint is wrong, but the sheriff is still enforcing the eviction notice because it's the rules.
That is the perfect analogy, and that is why this Greenland moment is so important. It cracks the aura of the law.
What do you mean by aura?
We didn't think of law as this neutral thing. Like physics, gravity just is. The law just is. But when you look at Johnson v. McIntosh, you see it wasn't inevitable. It was a choice. Marshall made a choice to protect the empire over the rights of the people living there.
And if there was a choice then?
It can be a different choice now. But courts are slow. They hate overturning precedent. It would create chaos. I mean, imagine if the Supreme Court said tomorrow, actually the U.S. doesn't own the land. Every title deed in the country would suddenly have an asterisk next to it.
Absolute chaos. The economy would melt.
Which is why they cling to Johnson. Not because it's right, but because it's stable. But the sources we reviewed ask a really provocative question. How long can you maintain a legal system based on a lie that everyone acknowledges is a lie?
It feels like the emperor has no clothes moment. Everyone sees it, the Vatican sees it, the president maybe even accidentally pointed it out.
And indigenous legal scholars have been putting out for 200 years. The difference now is that the contradiction is hitting the mainstream geopolitical stage. When you use lived political reality as the standard for Greenland, you are implicitly endorsing the indigenous standard for America.
You're saying, we are here, we govern ourselves, we exist.
Exactly. The law currently treats European assertion as legally generative. It creates rights. And it treats indigenous presence as legally reducible, as rights that can be taken away. The Greenland comment flips an entire logic upside down.
It suggests that presence should be the source of rights, which seems obvious to us as humans, but is radical to BUS code.
Radical and necessary.
So what does this all mean for you listening? We have a soundbite about Greenland, dropped in the middle of a strategic pivot in 2026. It was probably just meant to be a tough negotiator move against Denmark. But boomerangs are dangerous things.
They do tend to come back.
And this one brings us face to face with the fact that the ground beneath our feet, legally speaking, is held together by a 200-year-old story that the storytellers themselves have stopped believing.
The question is, what happens when the legal system finally catches up to the moral reality? Because right now, the gap between what we say is just and what the law says is property is getting wider by the day.
That is a heavy question, but I think it's the right one to leave hanging. Thanks for diving into the 19th century and the future with us. And to you listening, next time you look at a property deed or sign a lease, just remember, there's a ghost ship from 1492 jocked in the fine print. We'll see you in the next deep dive.